Video Learning on Demand, Article 1796 to Article 1817. About the video presentation. This video contains a brief and explicit explanations of the articles with clear examples for the readers to easily understand those certain articles. This video contains the Chapter 2, Obligation of the Partners, Section 1, the obligations of the partners among themselves, Section 2, the property rights of a partner, and Section 3, the obligations of the partner with regards to third person. This video was made for academic purposes only, and it is a requirement in our subject, Business Laws and Regulations, and I am instructed to discuss certain articles for my final output on the said subject. I am hoping that this video will help you to clearly understand those certain articles. I am JT Kalingasan, a second-year accountancy student, and I am here to discuss Article 1796 to Article 1817 of the Law on Partnerships and Private Corporations. Now, let's begin. Section 1. The obligations of the partners among themselves. Article 1796 to Article 1809. Article 1796. The partnership shall be responsible to every partner for the amounts he may have disbursed on behalf of the partnership for the corresponding interest from the time of the expenses are made. It shall also answer to each partner for the obligations he may have contracted in good faith in the interest of the partnership business and for risk in consequences of its management. Responsibility of the partnership to partners. In the absence of any stipulation to the contrary, every partner is an agent of the partnership for the purpose of its business. Hence, the obligations of the partnership to every partner is, first, to refund amounts disbursed by him in behalf of the partnership, plus the corresponding interest from the time the expenses are made. Here, the law refers to loans or advancement made by a partner to the partnership other than capital contributed by him. Next is to answer for the obligation he may have contracted in good faith in the interest of the partnership business. And lastly, to answer for risk in consequence of its management. Being a mere agent, the partner is not personally liable provided, however, that he is free from all a fault, and he acted within the scope of his authority. Examples: the articles of Partnership X, composed of A, B, and C, provides that any purchase in excess of 50,000 must first be approved by all the partners. C made a purchase of goods out of his personal funds for 60,000 without the knowledge of the approval and of A and B. The partnership incurred a loss. In this case, C is not entitled to reimburse for the purchase. Article 1797. The losses and profits shall be distributed in conformity with the agreement, if only the share of each partner in the profits has been agreed upon. The share of each in the losses shall be in the same proportion. In the absence of stipulation, the share of each partner in the profits and losses shall be in proportion to what he may have contributed. But the industrial partner shall not be liable for the losses. As for the profits, the industrial partner shall receive such share as may be just equitable under the circumstances. If besides his service he has contributed capital, he shall also receive a share in the profits in proportion to his capital. Rules for distribution of profits and losses. This article and the two succeeding ones regulate the distribution of profits and losses among the partners. Distributions of profits. The partners share the profit according to their agreement subject to Article 1799. If there is no such agreement, the share of each capitalist partner shall be proportional to his capital contribution. This rule is based on the presumed will of the partners. The industrial partner shall receive such share which must be satisfied first before the capitalist partners shall divide the profits, as may be just and equitable under the circumstances. The share of an industrial partner in the profits is not fixed, as in the case of the capitalist partner, as it is very difficult to ascertain the value of the service of a person. Example, A, B, and C form a partnership whereby each of them contributed 30,000 pesos. They agreed that should the partnership realize profits, the same shall be distributed in the following proportions. A as a managing partner 40%, B 30%, and C 30%. In this case, the partners shall share the profits in conformity with their agreement. If there is no agreement with respect to the share of each partner, then they shall share the profits equally. Another example. Suppose the contributions of the partner as are follow. A 30,000, B 20,000, and C 10,000 with a total of 60,000 pesos. In the absence of stipulation, the share of each partner shall be in proportion to his contribution, that is A 3/6 or 50%, B 2/6 or 33%, and C 1/6 or 17%. If D is an industrial partner, he shall receive such share as may be just and equitable under the circumstances. Assuming that the partnership make a profit of 17,000, the partners may determine, considering all the circumstances, that D, as industrial partner, is entitled of 2,000. The balance of 15,000 will be divided among A, B, and C in proportion to their respective capital contribution. Now, if D, aside from his service, contributed 4,000, then he will also share in the balance of 15,000 in proportion to his contribution. Distributions of losses. The losses shall be distributed according to their agreement, subject to Article 1799. If there is no such agreement, but the contract provides for the share of the partners in the profit, the share of each in the losses shall be in accordance with the profit-sharing ratio. But the industrial partner shall not be liable for losses. The profits or losses of the partnership cannot be determined by taking into account the result of one particular transaction, but of all the transactions had. If there is also no profit sharing stipulated in the contract, then losses shall be borne by the partners in proportion to their capital contributions, but the purely industrial partner shall not be liable for the losses. Example. In the same example, the partners will share in the losses in conformity with their agreement. If they fail to agree as to sharing of losses, the share of each partner in the losses shall be in the same proportion stipulated with regard to share of each in the profit. A 40%, B 30%, and C 30%. If there is also no profit sharing ratio stipulated, then the losses shall be divided in proportion to their capital contributions. D, however, being an industrial partner, shall not be liable for losses, but the same shall be borne by A, B, and C, the capitalist partners. However, if D is also a capitalist partner, then he shall share in the losses in proportion to his contribution. Article 1798. If the partners have agreed to entrust to a third person the designation of the share of each one in the profits and losses, such designation may be impugned only when it is manifestly inequitable. In no case may a partner who has begun to execute the decision of the third person, or who has not impugned the same within a period of 3 months from the time he had knowledge thereof, complain of a such decision. The designation of losses and profits cannot be entrusted to one of the partners. Designation of share in profit and losses by a third person. The designation of the share in profits and losses may be delegated to a third person by common consent. This article speaks of a third person, not a partner, following the general rule in contracts that the fulfillment of a contract cannot be left to will of one of the contracting partners alone. The prohibition in the second paragraph against the entrusting the designation of losses and profits to one of the partners is necessary to guarantee the utmost impartiality in the distribution of shares in the profits and losses. Binding force of designation by third person. The designation by the third person would generally be binding unless manifestly inequitable. Even then, a partner who has begun to execute the decision of the third person, or who fails to impugn the same within the 3 months from the time he had acknowledged of it, can no longer complain. In such case, the partner is deemed guilty of stupel, or to have given his consent or ratification to the designation. The reason behind the comparatively short period of 3 months within which to impugn the designation is to forestall any paralyzation in the operations of the partnership. Article 1799. A stipulation which excludes one or more partners from any share in the profits or losses is void. Stipulation excluding partner from any share in profits or losses. Stipulation generally void, but partnership subsists. The law does not, as a general rule, allow a stipulation excluding one or more partners from any share in the profits and losses. The partnership must exist for the common benefit and interest of the partners. Hence, such an agreement would contravene the very purpose of the partnership contract, that is, profit sharing among the partners. However, although the stipulation is void, the partnership, if otherwise valid, subsists, and the profits or losses shall be apportioned as if there were no stipulation on the same. Stipulation, a factor to show no partnership exists. Where the partners expressly stipulate that there shall be no liability for losses, or where from the nature of the contract, it is clear that a party did not intend to share in the losses, such fact may be a factor in determining that no partnership exists. Thus, in a case, it was held that where one party sells personality to another for use in a business and agrees in payment to take one half of the profits that might be made, and he does not thereby agree to share in the losses. The third is where partner excluded is industrial partner. With reference to the industrial partner, since the law itself excludes him from losses, a stipulation exempting him from the losses is naturally valid. This is without prejudice, however, to the rights of a third person. Last is where stipulations provides for unequal shares. The limitation does not mean that partners cannot stipulate for unequal shares in the profits or losses, even their respective contributions are equal, unless The inequality is so gross that it is, in effect, a simulated form of or attempt to exclude a partner from any share in the profits or losses. Reasons for exemption of industrial partner from losses. The industrial partner is not liable for losses because he cannot withdraw the work or labor already done by him, unlike the capitalist partners who can withdraw their capital. Furthermore, if the partnership who fails to realize any profits, then he has labored in vain, and in a real sense, he has already contributed his share in the loss. Stipulation providing for unequal shares in the profits or losses. The limitation does not mean that the partners cannot stipulate for unequal shares in the profits or losses even if their respective contributions are equal. However, if the inequality is so gross that it is in effect a simulated form or attempt to exclude a partner from any share in the profits or losses, the stipulation shall be void. Article 1800. The partner who has been appointed manager in the articles of a partnership may execute all acts of administration despite the opposition of his partners, unless he should act in bad faith, and his power is irrevocable without just or lawful cause. The vote of the partners representing the controlling interest shall be necessary for such revocation of power. A power granted after the partnership has been constituted may be revoked at any time. Rights of Rights and obligations with respect to management. Unless the partnership agreement provides otherwise, each partner in a general partnership has a right to an equal voice in the conduct and the management of the partnership business, and the right is not dependent on the amount or size of the partner's capital contribution or services to the partnership. Of course, the partners may select a managing partner to make such allocation of functions as the need of the business dictate, especially in a large partnership. Article 1800 speaks of two distinct cases of appointments. The first one is the appointment as manager in the articles of a partnership. The partner appointed by common agreement in the articles of the partnership may execute all acts of administration, notwithstanding the opposition of the partners unless he should act in bad faith. His power is irrevocable only upon just and lawful cause and upon the vote of the partners representing the controlling interest. The reason for this principle is that the revocation represents a change in terms of the contract. The law presumes that the appointment thus constituted is, in effect, one of the conditions of the contract, and it is only logical that such appointment should not be revoked without the consent of all the partners, including the partner thus appointed. It is an elementary rule that no party to a contract can violate the law of the contract without the consent of others. Next is appointment as manager after constitution of the partnership. But the management granted by the partners after the partnership has been constituted independently of the articles of the partnership may be revoked at any time for any cause whatsoever. The reason for this provision is that in such case, the revocation is not founded on a change of will on the part of the partners, the appointment not being a condition of the contract, and it is merely a simple contract of agency, which may be revoked at any time. It is believed that the vote for revocation must also represent the controlling interest. It should be noted that Article 1800 refers to a partner, not a stranger, who has been appointed manager. As a rule, a partner is not entitled to compensation for his services other than his share of the profits. The scope of power of a managing partner. General rule. As a general rule, a partner appointed as manager has all the necessary and incidental powers to carry out the object of the partnership in the transaction of its business. Hence, unless expressly withheld, the minor power to issue receipt is included in the general powers of the manager, as this is in keeping with present-day business dealings. The manager of a partnership engaged in buying and selling is clothed with sufficient authority even without approval of the other partners to purchase on credit, as it is usual and customary to buy and sell on credit. The managing partner has authority to dismiss an employee, particularly when there is justifiable cause for dismissal, after complying with the requirements prescribed by law for terminating employment. Exemptions. The exception is when the powers of the manager are specifically restricted or expressly withheld. A managing partner cannot also exercise powers which are neither necessary nor incidental to carry out the object of the partnership. Hence, unless expressly granted, a partner designated as one of the managers to take charge of selling fish in Manila and the purchase of supplies has no authority to purchase for the partnership as a barge, a truck, and an adding machine. Inasmuch as neither of these properties can be considered as supplies for the partnership business, and neither can the managing partner of the partnership form for the purpose of operating a tailoring shop, sell or convey the tailoring shop which is partnership property without the consent of all the partners. A managing partner may not bind the partnership by a contract wholly foreign to its business. Thus, he has no authority to execute a mortgage on the firm's property to secure the debt of a third person for which the firm is not liable. Compensation for services rendered. Partner generally not entitled to compensation. In absence of an agreement to the contrary, no partner is entitled to compensation for his services to the partnership without the consent of all the other partners. Each member of the partnership assumes the duty to give his time, attention, and skill in the management of its affairs, and for this service, a share in the profits is his only compensation. The reason for the rule is that in helping managing the partnership affairs, he is practically taking care of his own interests or managing his own business. Exception. In proper cases, however, it can be implied from the circumstances that the parties intended a partner to receive additional compensation as where the partner's work was beyond normal partnership functions. Example, saving partnership property from a flood for which a partner spent much time and effort and incurred expenses, or in a capacity other than that of a partner. Example is performing clerical services of a resigned employee. Article 1801. If two or more partners have been entrusted with the management of the partnership without a specification of their respective duties or without stipulation that one of them shall not act without the consent of all others, each one may separately execute all acts of administration, but if any of one of them should oppose the acts of the others, the decision of the majority shall prevail. In case of tie, the matter shall be decided by the partners owning the controlling interest. Powers of two or more managing partner. Respective duties are unspecified. The rule in this case is that each one may separately perform acts of administration. If one or more of the managing partners shall oppose the acts of the others, then the decision of the majority per head of the managing partners shall prevail. Note that the right to oppose can be exercised only by those entrusted with the management of the partnership and not by any partner. In case of tie, the matter shall have been decided by the vote of the partners owning the controlling interest that is more than 50% of the capital investment. Respective duties specified. If there is a specification of the respective duties of the managing partners, the decision of the partner concerned shall prevail, subject only to the limitation that he should act in good faith. Requisites for application of rule. The rule in Article 1801 applies only when the following requisites are present. Two or more partners have been appointed as managers. There is no specification of their respective duties. And there is no stipulation that one of them shall not act without the consent of all the other partners. Examples. The respective interests of the partners in a partnership are as follows: A 5%, B 10%, C 15%, D 15%, E 20%, and F 35%. A, B, and E were appointed as managing partners without specification of their respective duties. A contract entered into by A if with conformity of B, although against the objection of E, is valid. If the managing partners are A, B, and C sided with E, so that there was a tie, and when the matter was put to a vote of all the partners, A, B, and D were in favor with C and E and F. Again, the contrary is not valid. If A and E were the ones who originally vote in favor of the contract and subsequently F sided with them, the transaction is deemed ratified by controlling interest in the partnership. Suppose after a tie, the voting is as follows: A, B, and F in favor, and C and D against, both sides representing 50% of the interest, with neither side willing to give the way to other. What shall be the rule? The law is silent on this point. It is believed that in such case, the contract shall be considered as having been entered into without authority. In other words, when the partners are equally divided, those who vote against the contract or who resist change must prevail. The best solution is for the partners to dissolve the partnership. A shall be responsible for damages if it is found that he was at fault. If the contract is merely proposed, it may or may not be entered into depending upon the decision of the majority of the managing partners or of the controlling interest, as the case may be. Article 1802. In case it should have been stipulated that none of the managing partners shall act without the consent of the others, the concurrence of all shall be necessary for the validity of the acts, and the absence or disability of any one of them cannot be alleged, unless there is imminent danger of grave or irreparable injury to the partnership. where anonymity of action is stipulated. First, concurrence necessary for validity of acts. The partners may stipulate that none of the managing partners shall act without the consent of the others. In such case, the unanimous consent of all the managing partners shall be necessary for the validity of their acts. This consent is so indispensable that neither the absence nor disability of any one of them may be alleged as an excuse or justification to dispense with this requirement. The exemption is when there is an imminent danger of grave or irreparable injury to the partnership. A partner may act alone without the consent of the partner who is absent or under disability, without prejudice to former's liability for damages under Article 1794. The consent of the managing partner is also not necessary in routine transactions. Example is purchase in the regular course of business by a managing partner of a partnership engaged in buying and selling merchandise or goods regularly purchased by the partnership. Illustrative case. A sold to B, one of the managing partners of the partnership X, the other being C, a certain number of mining claims without the consent of C. In an action by A to recover the unpaid balance of the purchase price against partnership X, C claims that the contract is not binding upon the partnership for the reason that under the Articles of Partnership, there is stipulation that one of the partners cannot bind the firm by written contract without the consent of the others. Issue. Is the transaction may be made by B binding upon the partnership? Yes. The stipulation undoubtedly creates an obligation between the two partners, which consists in asking the other's consent before contracting for the partnership. This obligation, of course, is not imposed upon third person who contracts with a partnership. A third person may and has a right to presume that the managing partner with whom he contracts has, in the ordinary and usual course of business, the consent of his co-partner, for otherwise he would not enter into the contract. The reason or purpose is no other than to protect a third person who contracts with one of the managing partners from fraud or deceit to which he can an easy victim. Article 1803. When the manner of management has not been agreed upon, the following rules shall be observed. All the partners shall be considered agents, and whatever any one of them may do alone shall bind the partnership, without prejudice to the provisions of Article 1801. None of the partners may, without the consent of the others, make any important alteration in the immovable property of the partnership, even if it may be useful to the partnership. But if the refusal of consent by the other partners is manifestly prejudicial to the interest of the partnership, the court's intervention may be sought. Rules when manner of management has not been agreed upon. First, all the partners considered managers. The partners may fail to designate who among them shall act as managers, either when their contract is perfected or subsequently. In such case, all of them shall be considered managers and agents, and whatever any one of them may do alone shall bind the partnership subject, however, to the provision of Article 1801 that in case of timely opposition of any partner, the matter shall first be decided by the majority vote for the presumed intent is for all the partners to manage. In case of tie, then the matter shall be decided by the vote of the partners representing the controlling interest. Example, thus, in the example given under 1801, Article 1801, if A, B, C, and D are in favor of particular transaction, their decision shall prevail, although they do not represent the controlling interest. In case of tie, the controlling interest rule shall govern. Second, unanimous consent required for any important alteration in immovable property of partnership. Under the second paragraph, the unanimous consent of all partners is necessary for any important alteration in the immovable property of the partnership. The consent need not be expressed, and it may be presumed from the fact of knowledge of the alteration without interposing any objection. This prohibition applies only to immovable property because of the greater importance of this kind of property as compared to movable property. Any important alteration in the immovable property of the partnership is an act of strict domination. Hence, even the managing partners cannot make such alteration without the consent of all the partners. If the refusal to give consent by the other partners is manifestly prejudicial to the interests of the partnership, the intervention by the court may be sought for authority to make the necessary alteration. Under the second paragraph, if the alteration of the immovable property is necessary for its preservation, not merely useful to the partnership, the consent of the other partners is required. Illustrative case. A, B, and C organize a partnership for the purpose of engaging in the transportation business. Without a previous express authority, a contracted an indebtedness for automobile supplies and accessories. Are the partnership and the partners liable for said indebtedness? Yes, there being no agreement with regards to the manner of management, all the partners are considered agents of the partnership. A must be deemed to have authority to contract the indebtedness in question in as much as it was incurred in the prosecution of the partnership business. Article 1804. Every partner may associate another person with him in his share, but the associate shall not be admitted into the partnership without the consent of all the other partners, even if the partner having an associate should be a manager. Contract of sub-partnership. First is the nature. A partner may associate another person with him in his share without the consent of the other partners. Such associate is sometimes referred to as sub-partner. The partnership formed between a member of a partnership and a third person for a division of the profits coming to him from the partnership enterprise is termed sub-partnership. In effect, a sub-partnership is a partnership within a partnership but is separate and distinct from the latter. Second is the division of profits. How profits between the members of a sub-partnership are to be divided is immaterial, and the mere fact that one who is not a partner of an original partnership is to receive the entire profit of the business will not prevent the formation of a sub-partnership. Right of a person associate with partner share. Sub-partnership agreements do not in any way affect the composition, existence or operations of the firm. The sub-partners are partners in terms, but in the absence of mutual assent of all the parties, a sub-partner does not become a member of a partnership even though the agreement is known to the other members of the firm. Not being a member of the partnership, he may not acquire the rights of a partner nor is liable for its debts. Example: A, B, and C are partners, and A may contract with D, whereby the latter will participate in his share and in the profit of the partnership. This A can do independently of the partnership in accordance with the principle of freedom to contract. The original contract of partnership between A, B, and C is not in any manner altered. D is considered merely a creditor of A who associated him in his share. Consequently, D has no right to intervene in the partnership to which he is a mere stranger. Like an assignee, D cannot interfere in the management or administration of the partnership business, require information or account, or inspect partnership books. He continues in the enjoyment of the rights and remains subject to the liabilities of a partner as though no contract has been made him with D. D does not become a partner, nor is he liable for the partnership debts, even if the agreement between A and D is with the knowledge of and assent of B and C. D is an investor. Reason for this rule: for a sub-partner to become a partner, all the other partners must consent even if the partner who associated the sub-partner should be the manager, because partnership is based on mutual trust and confidence among the partners. Furthermore, the inclusion of the sub-partner as a new partner will in effect be a modification of the original contract of partnership, requiring the unanimous consent of all the partners, and it would seem that the prohibition applies even if the person associated is already a partner. Article 1805. The partnership books shall be kept, subject to any agreement between the partners, at the principal place of business of the partnership, and every partner shall at any reasonable hour has access to and may inspect and copy any of them. Duty to keep partnership books. The duty to keep true and correct books showing the firm's account, such books being at all times open to inspection of all members of the firm, primarily rest on managing or active partner or the particular partner given record-keeping duties. It is presumed that the partners have knowledge of the contents of the partnership books and that said books state accurately the state of accounts. Rights with respect to partnership books. A partner is a co-owner of the partnership properties, which include the books of the partnership. Subject to any agreement to the contrary, the partnership books should be kept at the principal place of business, as each partner has right to free access to them and to inspect or copy any of them at a reasonable hour, even after dissolution. This right is granted to enable the partners to have true and full information of all the things affecting the partnership. Access to partnership books at any reasonable hour. Article 1805 declares that the rights of the partners with respect to partnership books can be exercised at any reasonable hour. The phrase has been interpreted to mean reasonable hours on business days throughout the year and not merely during some arbitrary period of a few days chosen by the managing partners. The partner's inspection rights are not absolute, and he can be restrained from using the information gathered for other than partnership purpose. Article 1806. Partners shall render on demand true and full information of all things affecting the partnership to any partner or the legal representative or of any deceased partner or of any partner under legal disability. Duty to render information. Under the same principle of mutual trust and confidence among partners, there must be no concealment between them in all matters affecting the partnership. Hence, the duty to render true and full information of all things affecting the same upon request or demand. The information given to be true must be used only for partnership purpose. The use of the words on demand does not mean that a partner is under no duty to make voluntary disclosure of information affecting the partnership. Not only is a partner bound to give information on demand, but in certain circumstances, he is under the duty of voluntary disclosure of material facts within his exclusive knowledge relating or affecting the partnership affairs. But the duty to render information does not arise with respect to matters appearing on the partnership books, since each partner has the right to inspect the books. Example: A and B are partners engaged in real estate business. A learned that C was interested in buying a certain parcel of land owned by the partnership, even for a high price. Without informing B, A was able to make B sell to him his share in the partnership. Then A sold the land at big profit. In this case, A is liable to B for the latter's share in the profits when A purchased B's interest, and A was under the duty to make disclosure of facts having a bearing on the value of such interest which were not known to B. If A discovered a valuable mine, this is another example. If A discovered a valuable mine on a land of partnership, he is under a duty to disclose such information before purchasing interest of B. Article 1807. Every partner must account to the partnership for any benefit and hold as trustee for it any profits derived by him without the consent of the other partners from any transaction connected with the formation, conduct, or liquidation of the partnership or from any use by him of its property. Partner accountable as fiduciary. The relation between the partners is essentially fiduciary, that is, involving trust and confidence, each partner being considered in law as he is in fact the confidential agent of the others. First is the duty to act for common benefit. It is the obligation of a partner to act for the common benefit of all in all transactions relating to the partnership business or affairs. He cannot, at the expense or to the detriment of the other partners, use or apply exclusively to his own individual benefit partnership assets or the results of the knowledge and information gained by him in the character of a partner. Second is the duty to account for secret and similar profits. A partner, therefore, who makes a secret profit out of the operation of the partnership or who accepts a secret commission from a third person dealing with the partnership is duty bound to account such profit or commission with his co-partners. Third is duty to account for earnings accruing even after termination of partnership. The duty of a former partner to share profits with his former associates may extend to earnings accruing after the termination of the partnership. The true rule according to a case is when a partner wrongfully snatches a seed of opportunity from the granary of his firm, he cannot thereafter excuse himself from sharing with his co-partners the fruits of its planting, even though the harvest occur after they have terminated the association. Last is the duty to make full disclosure of information affecting the partnership. The duties of a partner are analogous to those of a trustee. It is therefore his obligation to act for the common benefit in all transactions relating to the partnership because business or affairs. He cannot, to the detriment of the other partners, apply exclusively to his own benefit the results of the knowledge and information gained in the character of a partner. Example, A and B are partners engaged in a real estate business, and A bought a parcel of land with partnership funds in his own name and subsequently sold the same at a profit. B has a right to share in the profit, and A holds as a trustee the profit derived by him from the transaction. Illustrative case. A and B were partners in the operation of a cinema business. The theater was mortgaged to C, who foreclosed the mortgage debt. A, in his own behalf, redeemed the property with his own private funds. Subsequently, A filed a petition for the cancellation of the old title of the partnership and the issuance of another title in his name alone. Did A become absolute owner of the property? No. In this case, when A redeemed the property in question, he became a trustee for the benefit of his co-partner, B, subject to his right to demand from the latter his contribution to the price of redemption plus legal interest. Article 1808. The capitalist partners cannot engage for their own account in any operation which is of the kind of business in which the partnership is engaged, unless there is a stipulation to the contrary. Any capitalist partner violating this prohibition shall bring to the common funds any profits accruing to him from his transactions and shall personally bear all the losses. Right of capitalist partner to engage in business. The capitalist partner is only prohibited by engaging for his own account in any operation which is the same as or similar to the business in which the partnership is engaged. Any capitalist partner violating this prohibition shall be under obligation to bring to the common fund any profits derived by him from his transaction, and in case of losses, he shall bear them alone. The partners, however, by stipulation may permit the capitalist partner to engage in the same kind of business. The law does not prohibit a partner from engaging in enterprises in his own behalf during the period that he is a member of a firm, but permits him to carry on a business or activity not connected or competing with that of the partnership, as long as the partnership agreement does not prohibit such activity. Any other rule it is said, would prevent a member of a partnership from investing his private funds. The law is silent on whether a capitalist partner can engage in the same line of business for the account of another. It is believed that the prohibition also applies, and partnership is a fiduciary relation involving trust and confidence. Each partner owes his co-partners utmost good faith, loyalty, and integrity. Without prohibition, the partner may sacrifice the interest of the partnership to favor his employer. Reason for the prohibition. It is universal that a capitalist partner, without the consent of his co-partners, cannot carry on a business on the same nature and competition with that of the firm. Since the relationship of partners is fiduciary and imposes upon them the obligation of the utmost good faith in their dealings with one another with respect to partnership affairs. One partner will not be permitted to retain for himself alone, as against to his co-partners, benefits from the partnership relation. This principle prevents a partner from availing himself personally of information obtained by him in the course of transaction of the partnership business or by reason of his connection with the firm regarding the business secrets and clientele of the firm to its prejudice. Article 1809. Any partner shall have the right to formal account as to partnership affairs. If he is wrongfully excluded from the partnership, business, or possession of its property by his co-partners. If the right exists under the terms of any agreement, as provided by Article 1807, whenever other circumstances render it just and reasonable. Right of a partner to formal account. General rule. In general, during the existence of the partnership, a partner is not entitled to a formal account of partnership affairs. The reason is that the rights of the partner to know partnership affairs are amply protected in Articles 1805 and Article 1806. Furthermore, to entitle any partner to the right to constantly demand or ask for a formal accounting will cause much inconvenience and unnecessary waste of time. Exceptions. However, in the special and unusual situations enumerated under Article 1809, the justification for a formal accounting even before dissolution of the partnership cannot be doubted. An example under number 4 of Article 1809 is where a partner has been assigned abroad for a long period of time in connection with the partnership business and the partnership books during such period being in the possession of the other partners. The right of a partner to demand an accounting without bringing about dissolution is necessary corollary to his right to share in the profits. A formal account is a necessary incident to the dissolution of partnership. Now, let us proceed to Section 2, Property Rights of a Partner, with articles covering 1810 to 1814. Article 1810. The property rights of a partner are his rights in specific partnership property, his interest in the partnership, and his right to participate in the management. Extent of property rights of a partner are principal rights and related rights. First, the principal rights is the property rights of a partner enumerated under the law are as follows: his rights in specific partnership property, his interest in the partnership, and his right to participate in the management. Second is the related rights. A partner has other rights which are related to above, namely, the right to reimbursement for amounts advanced to the partnership and to indemnification for risk in consequence of management, the right of access and inspection of a partnership books, the right to true and full information of all things affecting the partnership, the right to formal account the partnership affairs under certain circumstances, and the right to have the partnership dissolved under certain conditions. Partnership property and partnership capital distinguish. The distinctions are: first, changes in value. The partnership property is variable and it remains unchanged as the amount fixed by agreement of the partners and is not affected by fluctuations in the value of partnership property. The second distinction is asset included. Partnership property includes not only original capital contributions of the partners, but all property subsequently acquired on account of the partnership or with partnership funds, including the partnership name and the goodwill of the partnership. While the partnership capital represents the aggregate of the individual contributions made by the partners, such contributions may be in cash or in property of services, the value of which has been fixed in the partnership agreements. They are returnable on dissolution. Ownership of a certain property. Property used by the partnership. It is not unusual for an individual partner to allow his property to be used in the partnership business without intending to transfer ownership of it. A partner may contribute to the partnership only the use or enjoyment of property, reserving the ownership thereof. Or he may allow the partnership to use his separate property without having it become part of partnership property. Also, he may hold the title of the partnership property in his own name without having it belong to him. The intent of the parties, whether the property in question shall be belong to the partnership or themselves, is the controlling factor. Second is the property acquired by a partner with partnership funds. Unless a contrary intention appears, property acquired by a partner in his own name with the partnership funds is presumed to be partnership property. The presumption created by the use of such funds can be overcome only by a great deal of contrary evidence. However, if the property was acquired after dissolution, but before the winding up of partnership affairs, it would be his separate property, but he would be liable to account to the partnership for funds used in its acquisition. The third is property carried in the partnership books as partnership assets. This fact creates a very strong inference that it is a partnership property. The inference is stronger if the records carry as a partnership liability an unpaid balance on the property. Last is other factors tending to indicate property ownership. The fact that the income generated by the property is received by partnership or the tax thereon are paid by the partnership is evidence that the partnership is the owner, but the sole fact that partnership funds were later used to repair or maintain property purchased with funds of an individual partner is not sufficient as basis to show that the property not belongs to the partnership. Article 1811. A partner is co-owner with his partners of a specific partnership property. The incidents of this co-ownership are such that a partner, subject to provisions of this title to any agreement between the partners, has an equal right with his partners to possess specific partnership property for partnership purposes, but he has no right to possess such property for any other purpose without the consent of his partners. A partner's right in a specific partnership property is not assignable except in connection with the assignment of rights of all the partners in the same property. A partner's right in a specific partnership property is not subject to attachment or execution except on a claim against the partnership. When the partnership property is attached for a partnership debt, the partners or any of them or the representatives of a deceased partner cannot claim any right under the homestead or exemption laws. A partner's right in specific partnership property is not subject to legal support under Article 291. Nature of partner's right in specific partnership property. A partner is a co-owner with his partners of a specific partnership property, but the rules on co-ownership do not necessarily apply. The legal incidents of this common right in partnership are distinctively characteristic of the partnership relation, and they are as follows. First is the equal right of possession of the property for partnership purposes. Ordinarily, a partner has an equal right to possess specific partnership property for partnership purposes. Thus, if the partnership of A, B, and C owns a specific parcel of land, none of them can possess and use the land other than for partnership purposes. Should any of them use the land for his own profit, he must account to the others for the profits derived therefrom. Any partner should have the right to formal account of partnership affairs if he is wrongfully excluded from the possession of its property by his co-partners. The wrongful exclusive possession of the partnership property by one or more partners may be ground for dissolution. By agreement, the right to possess specific partnership property may be surrendered, and this is especially true of a partnership with large membership, where the management and possession are concentrated in the managing partners. Second is the assignment of the right to the property. Partner A, B, or C cannot assign his right to the land, but all of them can assign their rights in the same property. A. A partner's right in specific partnership property is not assignable because it is impossible to determine the extent of his beneficial interest in the property until after the liquidation of the partnership affairs. As property of the partnership, the same could not be disposed of or mortgaged even by the partner who contributed the same without the consent or approval of the partnership or of the other partners. Next is the attachment or execution. In the same example above, the land, strictly speaking, is not considered the separate or individual property of A, B, and C, and it belongs to the partnership considered as a juridical person. A partner has no interest in it but his share of what remains after all partnership debts are paid. Consequently, the land is not just subject to attachment or execution except on a claim against the partnership. For the same reason that the land belongs to partnership A, B, and C cannot claim any right under the homestead, or exemption loss when it is attached for the partnership debts, but a partner's interest in the partnership itself may be levied upon a judgment creditor because it is actually his property. Next is the legal support. The right of A, B, and C to the land is not subject to legal support under Article 195 of the Family Code. The reason is also because the land belongs to the partnership and not to the partners. But their interest in the partnership is, of course, subject to legal support. And lastly, the partner's interest, not a debt due from partnership. It is clear from the above that although separate creditors of an individual partner may reach the interest of a partner in the partnership, they cannot go after any specific partnership property. A partner is not a creditor of the partnership for the amount of his share. His interest in the partnership is not a debt of the partnership to him. Article 1812. A partner's interest in the partnership is his share of profits and surplus. Nature of partner's interest in the partnership. First is the share of the profits and surplus. The partner's interest in the partnership consists of his proportionate share in the profits during the life of the partnership as a going concern and his share in the surplus after its dissolution. This interest is assignable by the partner in the absence of any agreement to the contrary being personal property. Profit means the excess of returns over expenditure in a transaction or series of transactions, or the net income of the partnership for a given period of time. Surplus refers to the assets of the partnership after partnership debts and liabilities are paid and settled, and the rights of the partners among themselves are adjusted. It is the excess of assets over liabilities. If the liabilities are more than the assets, the difference represents the extent of the loss. The profits are shared in conformity with the agreement, otherwise in proportion to the capital contribution, but the industrial partner shall receive such share as may be just and equitable under the circumstances. Second is the extent of the partner's interest. Nothing is to be considered as the share of the partner but his proportion of the residue or balance after an account has been taken of the debts and credits, including the amount paid by several partners in liquidating firm debts and or in making advances to the partnership, and until that occurs, it is impossible to determine the extent of his interest. This interest in the surplus alone is available for the satisfaction of the separate debts of the partners. On the dissolution of the partnership, the value of partners' share usually cannot be accurately determined until liquidation of the business has been taken place and partnership accounts has been settled. Article 1813. A conveyance by a partner of his whole in the partnership does not of itself dissolve the partnership or as against the other partner in the absence of agreement, entitle the assignee during the continuance of the partnership to, to interfere the management or administration of the partnership business or affairs, or to require any information or account of partnership transactions, or to inspect partnership books, but it merely entitles the assignee to receive in accordance with his contract the profits to which the assigning partner would otherwise be entitled. However, in case of fraud in the management of the partnership, The assignee may avail himself of the usual remedies. In case of a dissolution of the partnership, the assignee is entitled to receive his assignor's interest and may require an account from the date only the last account agreed to by all the partners. Effect of assignment of partners' whole interest in the partnership. This article permits the conveyance by partner of his whole interest in the partnership without causing dissolution to any of his partners or to a third person without the consent of the other partners in the absence of agreement to the contrary. Note that a partnership right in a specific partnership is not assignable. First is the right withheld from assignee. However, such assignment does not grant the assignee the right to interfere in the management, to require any information or account, or to inspect any of the partnership books. Second is the status and rights of a assignor in partnership unaffected. The legal effect of such conveyance is the same as that of a partner associating another in his share or interest. Partnership is a relation which delectus personae or mutual agency in an important element. No one can become a partner without the consent of other partners. The assignment does not divest the assignor of his status and the rights as a partner nor operate as a dissolution of the partnership. Dissolution, dissolution of the partnership. There are two types, the dissolution not intended and dissolution intended. The first is dissolution not intended. The mere assignment of partners' interest does not dissolve the partnership. Many partnership agreements are made merely as security for loans, and the assigning partner never intending to destroy the partnership relation. Moreover, if the assigning partner neglects his partnership duties after assignment, the other partners may dissolve the partnership under Article 1830, which provides that dissolution is caused by express the will of all the partners who have not assigned their interest or suffered them to be charged for their separate debts either before or after termination of any specified term or particular undertaking. Next is dissolution intended. A partner's conveyance of his interest in the partnership operates as a dissolution of the partnership only when it is clear that the parties contemplated and intended the entire withdrawal from the partnership of such partner and the termination of the partnership as between the partners. Article 1814. Without prejudice to the preferred rights of the partnership creditors under Article 1827, on due application to a competent court by any judgment creditor of a partner, the court which entered the judgment or any other court may charge the interest of the debtor partner with payment of the unsatisfied amount of such judgment debt with interest thereon, and may then or later appoint a receiver of his share of profits and of any other money due or to fall due to him in respect of the partnership, and make all other orders, directions, accounts, and inquiries which the debtor partner might have made, or which the circumstances of the case may require. The interest charge may be redeemed at any time before foreclosure or in case of a sale being directed by the court, may be purchased without thereby causing a dissolution. With separate property by any one or more of the partners, or with the partnership property by any one or more of the partners with the consent of all the partners whose interests are not so charged or sold. Nothing in this title shall be held to deprive a partner of his right, if any, under the exemption laws as regard his interest in the partnership. Remedies of separate judgment creditor of a partner. First is application for a changing order after securing judgment on his credit. A separate creditor of a partner cannot attach or levy upon specific partnership property for the satisfaction of his credit. He can, however, secure a judgment on his credit and then apply to the court for charging order, subjecting the interest of the debtor partner in the partnership with the payment of unsatisfied amount of such judgment with interest thereon. Second, preferred rights of partnership creditors. The above remedies given to a partner's creditor are without prejudice to preferred rights of partnership creditors under Article 1827. It means that the claims of partnership creditors must be satisfied first before the separate creditors of the partners can be paid out of the interest charge. Third is the availability of other remedies. In providing for charging order above described, Article 1814 seems to have made this an exclusive remedy so that a writ of execution will not be proper. The court may resort to other courses of action provided in Article 1814 if judgment debts remain unsatisfied, notwithstanding the issuance of charging order. A similar procedure is established by Article 1862 as to private creditors of a limited partner. Example, T recovers a judgment against a member of Partnership X composed of A and B, on A's individual liability. The partnership is very profitable and B is solvent, but A is in deep financial trouble. May T attach any portion of the partnership property or execute against the same or go after A's share in the partnership assets? No. This remedy is to apply for a charging order from a court against the partnership. No specific property is attached. The partnership continues and this judgment is satisfied out of partnership assets. Under the charging order, A's share in the profits is paid to T until the claims of T are fully paid. The partnership need not be necessarily dissolved. B is protected. Only A, the debtor, suffers. Redemption or purchase of interest charge. First, the redemptioner. The interest of the debtor partner so charged may be redeemed with the separate property of any one or more of the partners, or with partnership property, but with the consent of all the partners whose interests are not so charged or sold. Redemption price. In an ordinary sale, the price of the things sold theoretically represents its market or actual value. This is not true in foreclosure sale where mere inadequacy of the price obtained at the sheriff's sale is not material because of mortgagor is given the right to redeem. By the same token, the value of the partner's interest in the partnership has no bearing on the redemption price, which is likely to be lower since it will be dependent on the amount of the unsatisfied judgment debt. Third is the right of redeeming non-debtor partner. For this reason, the redeeming non-debtor partner it is believed does not acquire absolute ownership over the debtor partner's interest, but holds it trust for him consistent with principles of fiduciary relationship. Example, A, B, and C are partners. A is personally indebted to X in the sum of 100,000 pesos. X filed a complaint against A and obtained from the court a final judgment in his favor. If A is insolvent, X can ask the same court or any competent court that A's interest in the partnership be attached or levied upon the payment of his debt. The other partners, B and C, may redeem or purchase the interest of A, the debtor partner, before the foreclosure sale or before the redemption period fixed by the court without dissolving the partnership. But such redemption or purchase is a ground for the other partners to ask for classification of the partnership. Right of a partner under exemption laws. Under Article 1811, a partner cannot claim any right under the homestead laws or exemption laws when specific partnership property is attached for partnership debt. With respect, however, to the partner's interest in the partnership as distinguished from his interest in specific partnership property, the partner may avail himself of the exemption laws after partnership debts has been paid. A partner's interest or share in the partnership is really his property. Now, let us proceed to Section 3, Obligations of the Partners with regard to third persons. I will only discuss the Article 1815 to Article 1817. Article 1815. Every partnership shall operate under a firm name which may or may not include the name of one or more of the partners. Those who, not being partners of the members of the partnership, include their names in the firm name shall be subject to liability of a partner. The word firm is defined as the name, title, or style under which a company transacts business. A partnership of two or more persons, a commercial house, and in its common acception, the term implies a partnership. The term is also used as synonymous with a company. A partnership must have a firm name under which it will operate. A firm name is necessary to distinguish the partnership, which has a distinct and separate juridical personality, from the individuals composing the partnership and from other partnership, and thus helps to facilitate business transactions by the partnership. Under the business name law, such firm name must be registered with Bureau of Commerce and now is the Department of Trade and Industry. Right of a partners to choose firm name. The firm name of a partnership may be that on an individual partner, the surnames of all the partners, or the surname of one or the surnames of one of more of the partners with the addition of "and company." Or it may consist of individual names wholly distinct from the names of any of the members. 1. The use of misleading name. The partnership may adopt any name it wishes as long as it is not identical with or deceptively similar to a name which was previously adopted by any other entity, or interfere with the rights of others, or is contrary to law. 2. Use of names of deceased persons. The Supreme Court has ruled that a partnership cannot continue to use in its firm name the names of a deceased partner, for such use will run counter to Article 1815. In fact, Article 1830 ordains that a partnership is dissolved by the death of a partner, and it is clear in above provision that names in a firm name of a partnership must either be those of living partners and, in the case of non-partners, should be living persons who can be subjected to liability. The above ruling must be considered abandoned or no longer applicable in view of Rule 302 of Code of Professional Responsibilities, approved and adopted by Supreme Court on June 21, 1988, which provides in the choice of a firm name, no false, misleading, or assumed name shall be used. The continued use of the name of a deceased partner is permissible provided that the firm indicates in all of its communication that the said partner is deceased. Example, A, who retired as a member of a partnership X, executed a legacy to the partnership, then composed B, C, and D. A few years later, A died. At the time of his death, the partnership was composed of E, F, and G. The former members having predeceased A, the partnership was continued by agreement of the partners whenever there was a change in membership. The legacy vests in partnership X, notwithstanding that E, F, and G were unknown to A during his lifetime. It may be argued, however, that the intention of A was to give the legacy to the old partnership which no longer exists. Liability for inclusion of a name in firm name. Persons who, not being partners, include their names in the firm name do not acquire the rights of a partner, but under Article 1815, they shall be subject to the liability of a partner insofar as third person without notice are concerned. Article 1815 does not cover the case of a third person who represents himself to be a partner or of a limited partner who allows his name to be included in the firm name, or of a person continuing the business of a partnership after dissolution who uses the name of the dissolved partnership or the name of a deceased person as part thereof. Article 1816. All partners, including industrial ones, shall be liable pro rata with all their property and after all the partnership assets has been exhausted, for the contracts which may be entered into the name and for the account of the partnership, under its signature, and by a person authorized to act for the partnership. However, any partner may enter into a separate obligation to perform a partnership contract. Liability for contractual obligations of the partnership. First, partnership liability. Partners are principal to the other partners and agents for them and the partnership. They are liable to the third person who have dealt with one of them in the same way that a principal is liable to third persons who have dealt with an agent. The general rule is that a partner has the right to make all partners liable for contracts he makes for the partnership in the name for the account of the partnership. Individual liability. A partner, however, may assume a separate undertaking in his name with a third party to perform a partnership contract or make himself solidarily liable on a partnership contract. In such case, the partner is personally bound by his contract even if only the partnership is shown to have derived benefits from it. Nature of individual liability of partners. Article 1816 lays down the rule that the partners including the industrial partner, are liable to creditors of the partnership for the obligation contracted in the name and for the account of the partnership. The debts or and obligations of the partnership in substance, also the debts and obligation of each individual members of the firm, and the liability to creditor is pro rata and subsidiary. Number 1. Pro rata. As used in the law, the term must be understood to mean equally or jointly and not proportionately, which is its literal meaning because the prorating is based on the number of partners and not on the amount of their contributions to the common fund subject to adjustment among the partners. The fact that a partner has left the country and the payment of his share of the liability cannot be enforced, or his liability is condoned by the creditor, cannot increase the liability of the other partners. Number 2. The subsidiary or secondary. It is subsidiary because the partners become personally liable only after all the partnership assets have been exhausted, unless a particular partner assumes a separate obligation to perform a partnership contract or make himself solidarily liable on a partnership contract. Liability of industrial partner. Even the industrial partner, who ordinarily is not liable for losses, would have to pay, but of course, he can recover the amount he has paid from the capitalist partner unless there is an agreement to the contrary. Neither on principle of law or justice can the industrial partner be relieved from liability to third person for the debts of the partnership. Illustrative case. X company, a general partnership, purchased from A motor vehicle on installment basis. Upon failure of the partnership to pay installment, A sued it and the five partners B, C, D, and E and F. B failed to file an answer and was declared in default. Subsequently, on motion of A, the complaint was dismissed insofar as F was concerned. The rest of the defendants failed to appear at the hearing and were declared in default. Judgment was rendered against the partnership and the four partners B, C, D, and E. B and C moved to reconsider, saying that since there were five general partners, the joint and subsidiary liability of each partner should not exceed one-fifth of the obligation of the company. The lower court denied the motion, hence the appeal. Should B, C, and D and E alone be held liable for the obligation of the company in view of dismissal of the complaint with respect to F? No. In the instant case, there were five general partners when the promissory note in question was executed for and in behalf of the partnership. Since the liability of the partners are pro rata, the liability of each partner shall be limited to only one-fifth of the obligation of X company. The fact that the complaint against F was dismissed upon motion of A does not unmake F as a general partner in the defendant company. Distinction between a liability and a loss. There is a marked distinction between liability and a loss. The inability of a partnership to pay a debt to a third party at a particular time does not necessarily mean that the partnership business as a whole has been operated at a loss. The partnership may have been outstanding credits for which for the moment may be unavailable for the payment of the debts, but which eventually may be realized upon and yield profits more than the sufficient to cover all losses. The exemption of the industrial partner to pay losses relates exclusively to the settlement of the partnership affairs among the partners themselves, has nothing to do with the liabilities of the partners to third person. An industrial partner is not exempted from liability to third person for the debts of the partnership. Article 1816 refers to liabilities, while Article 1797 speaks of losses. There is, therefore, no conflict between the two articles. Example: A and B are capitalist partner, with C as an industrial partner. A and B contributed 10,000 each to the capital of the partnership. A contractual liability of 26,000 was incurred by the partnership in favor of D. Under Article 1816, D can sue the firm of all the partners including C, the industrial partner. The capital assets of 20,000 shall be exhausted, thereby leaving an unsatisfied liability of 6,000. D can recover the amount from A, B, and C jointly or pro rata at 2,000 pesos each. After paying D, C can recover for reimbursement of 1,000 pesos each from A and B under Article 1797. He is exempted from the loss of 6,000 pesos as among themselves unless there is a stipulation to the contrary. If, in the same example, the capital contributions of A and B are 15,000 pesos and 5,000 pesos respectively, in the absence of stipulation, they share in the loss of 6,000 in proportion to their contributions. To with A 3/4 or 4,500 pesos and B 1/4 or 1,500 pesos. Hence, B can recover 500 and C 2,000 from A. Article 1817. Any stipulation against the liability laid down in the preceding article shall be void except as among the partners. Stipulation against liability. A stipulation among the partners contrary to the pro rata and subsidiary liability expressly imposed by Article 1816 is void and no effect insofar as it affects the rights of third person, and it is valid and enforceable only as among the partners. Example: A, B, and C are partners in a business and each of them contributed 10,000 pesos each. They stipulated that the liability of A shall not exceed his capital contribution. Thus, if the partnership assets have been exhausted and there still remains an unpaid balance of 9,000 in favor of creditor D, the latter can still recover 3,000 pesos each from the partners as their stipulation cannot adversely affect him. However, since the agreement is binding among the partners, A is entitled to credit from B and C for the amount of 3,000 pesos paid by him to D. A, however, cannot recover his contribution of 10,000 pesos. That's all. Thank you, and I hope you have learned a lot from my presentation. God bless.